Okay. All right. And then I suppose the sheriff's office had some suggestions as far as sidebar conferences. Bill, I don't know do you guys have a plan? Do you communicate that to everybody or on sidebar conferences?
Well, I'm going to stand next to you, obviously, but
Yeah, I'm going to stand over here.
Yeah. And we're not comfortable, we've discussed internally in our office, going sidebar with the defendant, Judge.
Then you can stay over there, and then I'll take the sidebar conferences without you. You know,
Yes, sir. That's,
we have plenty of security here. I have no issues to think that there's going to be a problem. So,
yes, sir.
okay.
Your Honor, I understand that the state is going to go forward with cold, calculated, premeditated, and the previous violent crime aggravators only, and the previous violent crime would be basically contemporaneous homicides. I did do a motion to strike those. I think the court needs to rule on those.
Okay. Go ahead. You seen the motion, right?
Yes, sir.
Okay. What's
Yeah,
your response?
obviously,
You want to argue the motion, or that's the argument?
I would submit to my written motion, Your Honor, in brief, that I would argue that obviously cold, calculated, and premeditated means more than normal premeditation, and I would just submit to the court there's no real argument of any really prolonged planning in this case, any of the kind of premeditation and prior workup that would rise to the level of cold, calculated, and premeditated.
Okay. Let me read your motion. We're mixing a lot of apples and oranges here. Let's take them one at a time. There are 3 victims.
Yes, sir.
So the aggravators are going to be different as to at least 2 out of the 3 victims. I think the state somewhat conceded last week that hack does not apply to the murders
That's correct,
of
yes, sir.
Laquetta Gunther or
Or Ms.
Julie
Patton.
Green.
Or Ms. Patton either. We're going to not be seeking it out.
Okay, so you're not seeking hack on any of them.
That is correct, yes, sir.
Okay, and so that's out.
Yes, sir.
All right, so then that remains now with CCP.
Yes, sir.
And that's what you're arguing on CCP?
Yes, sir. That's,
Okay, CCP as to whom and why?
as to all of them, Your Honor,
Okay,
evidence pretty much admits that these were women that engaged in prostitution, and there's been evidence that the defendant utilizes prostitutes. And there is evidence of a gun, there is evidence of movement, transportation, but that's it.
okay. Give me a second. I'm going to read your motion real quick.
While you're reading it, Judge, just for the court's edification, there's also the sexual battery, felony murder one. We're not seeking that one either, Judge, so don't wait.
Well, let's stick with CCP.
Yes, sir.
Then we'll move on to the next. One at a
I thought
time.
you were reading the whole thing. I just wanted to.
Okay. Okay, so according to this, the aggravators that the state is still seeking are cold, calculated, premeditated, a prior conviction, felony conviction, and avoid arrest. That's it.
We are not seeking the avoid arrest, Judge, so it's just going to be the cold, calculated, premeditated, and prior violent felony.
That's it.
Yes, sir.
Oh. Okay, so now I'll just entertain argument as to the remaining ones. And I think you only have CCP you want to argue against?
Yes, sir. Your Honor, CCP was originally intended for gangland hit, mob execution type murders.
Can you do me a favor? Can you step at the podium?
Yes, sir.
There's no microphone where you are. I left my hearing aids at home, and showing my age, I guess. And I'll be able to hear you. You can't hear, even the court reporter's having a tough time hearing you. Okay, go ahead.
Your Honor, the CCP aggravating circumstance was originally intended for organized crime type hits and contract murders. And over the years, as I've indicated in my motion, it's been expanded to include just about anything with some minor heightened premeditation, and it really creates a grave risk of a normal premeditated first-degree murder being deemed cold, calculated, and premeditated for the same reason that the jury found it to be a premeditated murder. And in my motion, I've cited the Herring and Hansborough and McRae cases. The case law clearly indicates that CCP does not apply to frenzied kind of panic or rage murders. And the facts of this case do suggest that these killings were done in a panic, rage type manner.
Okay, thank you. What says the state in response? Very brief, please.
Yes, sir. The state would obviously object to that. We think there's more than sufficient evidence to establish the factors of cold, calculated, premeditated. We don't believe that these were rushed, hurried murder. They were pre-planned. Gun was acquired before. And can you hear me, Judge?
I can hear you fine.
And all the factors establishing with the Williams Rule evidence and all the other evidence establishes this is a clear plan of him, and he would get these folks and they would kill them all beforehand, plan it ahead of time, Judge.
Okay. Anything else?
Nothing on that.
Yeah, I would deny your request to strike CCP as an aggravator. Allow the state to present evidence of it. They already have, actually, through the trial. So, anything else?
With regard to the prior violent felonies based on the contemporaneous homicides in this case, Your Honor, I'm required to concede in my duty of candor to the tribunal that there is a large body of case law holding that contemporaneous murders, which would include the 3 murders in this case, do qualify as the prior violent felony aggravating circumstance. However, I would just ask the court to revisit the matter and decide the issue anew on its own, because I would submit to the court that prior violent felony should mean exactly what it says. It should be something prior, beforehand, not decided in the same trial.
Okay, thank you. I don't think I need any argument from the state. I believe the case law is very well established in that issue, so deny your request to strike that aggravator at this time.
And Your Honor, I need my chart, the one that I used. I was told it was wheeled back in the hallway.
Yeah, but I think I took it down, and I believe it's gone. Is it? Do you know where it is, Alyssa?
I'll go look for it.
Well, start off in the jury room, and I know I took it down because we. Okay, anything else we need to address before we get the jury? I'm going to have to go back to my office anyways. Yeah,
Yes,
but what do you got? The victim impact?
Yes, sir.
And there's an objection to victim impact?
I believe there's some, Judge. Defense this morning, we just highlighted some that they had.
Okay, what's been handed to me is 3 separate
Yes, sir. There's three different victims.
communications. I will identify them by whose name is at the bottom of the communication.
Yes, sir.
Rhonda Iwanski.
Yes, sir. That is for Ms. Green.
Ms. Green.
Yes, sir.
It's also signed Brittany Iwanski,
That's her, I think her daughter,
niece.
niece. The daughter
Niece
of
of-
Ms.
yeah, right.
Lewanski. I'm sorry, Judge. Yes.
Okay.
And just so the court knows, I did go through and edit these quite a bit beforehand.
I'm sorry?
I did go through and edit these quite a bit beforehand, Judge.
Okay.
So,
Oh, what you've handed me is what you proposed reading.
yes, sir. And certainly, if there's a few issues, we can talk through them. I just got it this morning, so we're looking at it together.
And who's reading them?
So for Ms. Iwanski, she's going to be on Zoom. She has a health issue and she's unable to travel.
Okay.
So she'll be reading her own, Ms.
Okay.
Iwanski. And then, Judge, for whenever you're ready to move on to the next ones, I can.
Let's take them one at a time.
Yes,
It'll
sir.
be easier. All right, okay, and then I've read so far the Iwanski letter. I'm assuming the highlighted things are the objections,
That is correct. Yes, sir.
okay?
Yes, sir, Your Honor, and my objections are all consistent, all for the same reasons.
I can't hear you.
Okay, I'm sorry. Well, I'll walk up. That'll pick up everything else. Your Honor, my objections are all the same. The case law is clear that the victim impact evidence is allowed to prove the uniqueness of the decedent and the resulting value to the community. Those two things, they're not allowed to put on grief or mourning evidence. And what I've highlighted out of the grief and mourning evidence,
Yeah.
I've left in there all of the relationship, the value information, the meaningfulness of the decedent, all that I left. It's just the effect, the grieving and the mourning.
All right. State, I have no problem with it, with the exception of the very last line, and that the event resulted in the bankruptcy,
Yes, sir.
and blaming this on the bankruptcy. I don't. So if you just don't mind striking the absolute last sentence, the last sentence. Other than the last sentence, I think the statement is appropriate. Okay.
Yes, sir.
All right, now I'm going to deal with, now there's a handwritten and a typed. I'm not sure. One is from Barbara.
Yes, one is from Barbara,
It's a
her
Ru-
mom. That is,
What is it?
it's Miss Green's mom, Barbara Roth. I think it's Rush.
And this is whose mom?
This is I'm sorry, this is Mrs. Gunther's mother.
Okay.
Miss Gunther's mother.
And what's the other one?
And the other one is from Miss Luster, who is her daughter, who is here in person. Her daughter will read both of the
Okay.
both of those, sir.
All right, let me read theirs, okay?
Yes, sir.
Okay, as to the statement by Nikki, that will be acceptable in its form without any redactions. Defense, you still need to object, renew your objection, I guess, the same. You want to make the same objection?
Yes, Your Honor, if I could just have the court agree I have a running objection, I won't have to interrupt.
Let's not have a running objection. Just reiterate after everyone. You just want to use the same objection, that the comments that you're objecting to, in this case, they're being highlighted in yellow. They will remain highlighted in yellow in the exhibits, so we know what you're objecting to.
Yes, sir.
And I'll just make that very clear.
And Judge, can you, in the exhibits, can you just on that last line of the first one we looked at, maybe draw through it too, knowing that that's what we're going to use? That's what we're updating now for Ms. Ivansky.
Okay.
Thank you, Judge.
I'll just strike through it and then write the word stricken next to it and put my initials
Yes, sir. Thank you, Judge.
and the date. That's fine. If you don't mind putting an ID number on this, Sherry. This will be Ms. Iwansky's statement. That's going to be part of the record. Okay, and then as to Barbara, how do you, the last name is what, Rurak?
I believe so, yes, sir.
Is it R-U-R-A-K?
Yes, sir.
Okay, as to Barbara Rurak's statement, you want to lodge the same objection?
Yes, sir.
Okay, and then likewise, I feel the statement is appropriate. We'll allow the statement to be read in its original format as presented to the court. And Chair, if you don't mind giving each of these a separate ID number, and just say on the record what they are. What was the first one, Iwanski's? ID what?
This one is going to be ID B.
Okay. B as in Bravo?
B is in Bravo.
Okay.
And who's that? Barbara Ruas, is that the last one you did, Judge?
Rurak, yeah.
Okay. This one, the Ruak will be C is in Charlie. And the last one will be D is in David.
Okay, very well. And then now I have one identified as, it says Patton family. There are,
I believe four.
it's just one, but it's a composite of
Yes, sir, I think
four,
there's four total, sir.
four separate statements. Okay. Did Alyssa ever come back? She never did.
Still looking.
Okay, and then I read the statement of, it said, Rachel Patton. Same objections by the defense, correct?
Yes, sir.
Okay, and then I find that the statement is appropriate and will be read as proposed to the court. Now I'm reading Dr. Anissa Ferris, which was Ms. Patton's niece. Okay, I read Dr. Ferris's statement, find that her statement is appropriate. The defense still has an objection, correct?
Yes, Your Honor, just the last line. that
Yeah.
I highlighted.
I'm going to overrule the objection, allow the statement to be read. Now I'm reading Naima, N-A-I-M-A-H, Naima. Okay, and there was no objection to Naima's statement, which, at least there's
Actually,
none
Your Honor,
highlighted.
The last three sentences of the first paragraph that read, "My sister Iwana Patton, I think about her every day. The holidays and birthdays are the worst. We'll never miss her. Such an impact on our life." I would object to that part of it
Okay,
for the same reasons. It goes in the mourning and grief.
okay, I find that the statement is appropriate. Now I'm reading Daryl, the nephew.
Your Honor, with regard to Daryl, the objection would be to the last sentences of the first two paragraphs.
Yeah.
Same reasons.
I'll overrule the objection. So, all right, thank you all very much. All right, I need to go back to my office for a second, but is there anything else we need to address before I go back there?
No, sir, the state would just renew to ask the court to adjudicate the defendant.
Yeah.
Yes, sir. Thank you.
Mr. Hayes, the jury having returned a verdict as to each count, in this case, as to the murder of Laquetta Gunther, I hereby adjudicate you guilty of the offense of first-degree premeditated murder with a firearm. As to count 2 for the murder of Julie Green, I'm going to adjudicate you guilty of first-degree premeditated murder with a firearm as charged in the indictment. And as to the murder of Iwana Patton, I adjudicate you guilty of first-degree murder with a firearm as charged in the indictment. We will proceed to sentencing when I return. Thank you. We'll be in recess for about 10 minutes, okay?
You want to know these
Yeah.
together?
I said composite.
Court's back in session.
Thank you, may be seated. Bill, will you come here for a second?
Yeah, I just wanted to turn on.
All right. We'll wait for Mr. Anderson. He's the last one.
For those of you in the audience, can you turn your cell phones off of vibrate, please? And there's no recording unless you're a member of the press.
No, she's an attorney with them. Are you an attorney with them?
Mitigation specialist,
I'm sorry?
the mitigation specialist.
Who do you work for the, oh, okay. That's part of their team. Okay. All right, you ready?
Yes, sir.
State?
Yes, Judge, we're ready.
Okay, then let's get adjourned.